Unsiloed podcast is produced by University FM, elevating the stories of your institution.
Welcome to Unsiloed. This is Greg LeBlanc. I'm here today with Randy Barnett, who is a professor of law at the Georgetown Center and also the author of a number of books. Most recently, this one called A Life for Liberty, The Making of an American Originalist, and also the author of a bunch of other books, including The Structure of Liberty, The Original Meaning of the 14th Amendment. Got a couple others here, Restoring the Lost Constitution, and Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Welcome, Randy.
Nice to be here. Thanks for having me.
So look, this book, I was intrigued by this book because, as far as I know, it is the only memoir of a law professor. Now, I don't know whether that speaks to the nature of being a law professor. Maybe it's not interesting enough to be worthy of a memoir, because it's definitely not because law professors can't write or don't like to write, because we all know that law professors can be very, very loquacious and write a lot, perhaps more than they should. But it's also a story of, I don't know, it's kind of a coming of age, or a journey to the center, from the periphery to the center in a bunch of different ways, from academic periphery to the academic center, but also ideologically and theoretically, the things that you've been interested in and the positions that you've taken were once pretty fringe, and now they seem to be at the heart and at the center of the legal discourse. And so maybe we can start by saying, why would you ever write a memoir? Why would you think that anybody would find the life of a law professor as interesting as you and I might find it?
Well, the original impetus for the project was when I had my first grandchild. So he's 8, so that would have been 8 years ago. And I thought that I've done so many interesting things in my life that my grandchildren, if I would like to know that about my grandfather, if he had done these things. But by the time they're old enough to appreciate, now I have 5 grandchildren, by the time they're old enough to appreciate these stories, I won't really be around to tell them. And besides, there's too many of them to sit down and tell anyway. So I essentially wanted to memorialize my life for their benefit. But in the course of writing the memoir, it struck me that there were lessons to be learned. There were two things. One is there were lessons to be learned by my career, my life and my career, and how I managed to go from the periphery to the center, because there's a lot of people who might aspire to do that. How do you do that? Secondarily, my life is deeply involved in 2 major intellectual movements. The first was the libertarian political movement, or the libertarian intellectual movement. And the second is the originalist movement within what is actually better referred to as the conservative legal movement. So I've been a player in both of these movements, and as a result of my involvement, those movements have been affected. And so my history is in some respects an intellectual history of both those movements. And a lot of people are interested in one or the other or both. And so I think that's how ultimately Encounter got interested in publishing the book, because there were, and it's also, I guess, thirdly, it's a behind the scenes story of the medical marijuana case that I helped bring, then ultimately argued in the Supreme Court, which was a big case at the time, and the Obamacare case, the Affordable Care Act challenge, which I formulated the theory as to why it was unconstitutional, and then eventually became one of the lawyers in the case. That's also a really big, and that was a huge case, and has had a major impact on constitutional law. Both cases have. And so this is a behind the scenes first person account of both of those litigations. And I know a lot of stuff that other people might be interested in finding out about, sort of what happened behind the scenes of those cases. So that's 3 things that I tried to accomplish. But the result of that is the book got kind of long. And as a result of the length of the book, I took out the chapters about my being a criminal prosecutor in Chicago. And I've now just finished a manuscript of that book, which will be my next book, on describing tales of true crime and corruption in Chicago, which is what the subtitle of the next book will be about.
Well, what's interesting is that those 2 cases that you mentioned in the Supreme Court, I mean, technically you lost them both, right?
So well, you might think that.
Yeah, well, that's the thing. I mean, it's a story of triumph in spite of the fact that technically you lost those cases, right?
Right. Well, in both cases, even in the first case, which we lost 6-3, the second case we lost ostensibly 5-4. In both of those cases, our most major accomplishment was preventing the court from adopting the government's theory of the case. In both cases, we succeeded in the court issuing a much narrower holding than the government's theory was. Had the government's theory prevailed in either of these cases, it would have been the end of the enumerated powers structural scheme of our Constitution, which says that Congress and the federal government is one of limited and enumerated powers, and the general powers reside in the states. That scheme would have been over if the government had prevailed in either case, but it didn't. We got Justice Stevens for the majority to adopt a more narrow reading of the statute in the medical marijuana case, and in the Obamacare case, we actually had 5 votes for our theory that an individual insurance or purchase mandate was unconstitutional. We had 5 votes that we were right on the Constitution. Normally, when you win on the law, that means you win the case. And if you've lost the case, it means you've lost on the law. But in this very, very weird case, we won on the law 5-4. And then we lost because the 5th vote, Justice Roberts, found a saving construction to impose upon the statute. So to make the statute not unconstitutional under our theory. And that's ultimately how we prevailed on the law. The government lost on the law, which was big. Yet, unfortunately, Obamacare, the Affordable Care Act, was upheld. So we lost the actual policy issue, the policy benefit.
Well, in addition to those 2 journeys that are in the book, there's a third journey, which is your journey from private law to public law. And I think this is very unusual. For people on the outside of the legal community and legal academia, they tend to think that con law is the most interesting thing, and that tends to be in the news quite a bit. It's kind of like in economics. Outsiders think that economists spend all their time doing macroeconomics, thinking about inflation and so forth. And very few economists actually do that. Same thing in the legal academia. I mean, most of us are concerned with things like, property and contracts and, secured transactions and so forth. And, con law has a much more higher profile in the general public. And I think that, most of the people who are con law professors, they go into law school, with a fascination for con law, and they make that their object of study. And you kind of got there through criminal law and contracts. And somebody said that you came to constitutional law too late in life to make an impact. Right?
Yeah.
So is there an advantage?
That was the dean of Northwestern Law School when he was when he was telling me, or he was telling one of his colleagues why he refused to extend me an offer of appointment that his faculty had voted unanimously to make to me. And his excuse, that wasn't his real reason, but the excuse he told one of the faculty members there who objected was that, in his opinion, I had moved into constitutional law too late to be a player.
Now, is there an advantage to this? I mean, I know that I probably spent years studying law before I finally got to con law, and I even took administrative law before con law, and I kind of looked at it very differently, right? As sort of, something that was built on top of corporation law and so forth. And that's not how most people approach it. Most people get con law, very early in their law school experience. I mean, is there an advantage? Do you think that you got some kind of insight into constitutional law that you might not have gotten if you hadn't taken this circuitous route to con law?
There's no question about it, and it has to do with the difference between the kind of law that exists in constitutional law versus the kind of law that exists in contracts, which was my specialty. My adopted specialty when I went into teaching was contract law, and that is, in contracts, there's real law that has developed over centuries, and it's demanding. Trying to figure out knowing what all that real law is. There's a lot of doctrine, there's a lot of law, and courts try to follow the law in those circumstances. And so as a scholar, as an academic, first of all, I have to know the law, which I didn't practice contract law. I practiced criminal law. I took a contract law class in law school, but that's not much. I mean, it was good, but it wasn't enough. So I had to learn the subject, and then I'm a legal theorist. So the idea was I had to write about it. And I developed a theory of contracts called the consent theory of contracts, which actually made a very big splash, had a big impact at the time I did it. And what I want to say is that that's very demanding. To create a theory of a very complicated body of law that legal decision makers take seriously is very challenging. In contrast, constitutional law is doctrine made by the Supreme Court of the United States, and although it can get complicated, I think it is not all that intellectually rigorous. It is a judge-made body of doctrines that changes a lot depending on the ideological or philosophical makeup of the justices. And so the doctrine is sort of epiphenomenal, as opposed to contract law, where the doctrine is really fundamental. And what I experienced was that being able to do contract law theory enabled and to be able to do it at all empowered me to do constitutional theory way better than people who have known nothing but constitutional law. And if I can put this more in a vernacular, constitutional law is largely bullshit, and contract law is not.
I think you sort of recognized that in law school.
Yeah.
Right? When you're Lawrence Tribe, I guess you were taking con law.
Yeah, which wasn't his fault. I mean, although he was a bullshit artist of the highest magnitude, which is really what most con law people are. It was the problem I had in law school was the Supreme Court and the decisions I was reading as a law student that convinced me that the Constitution was a failed experiment, that no matter what it said, the court was going to ignore the parts that limited federal power, limited state power, that protected individual rights, especially unenumerated rights. And so I sort of gave up on the Constitution once I seen what the Supreme Court had done with it, and then I got dragged into it reluctantly, as the book discusses. And now I don't do contract law anymore at all. I only do constitutional law, in part for the reasons you earlier said, and that's what's in public demand, whereas contract law is not in public demand.
Well, you had a story where you got sort of roped into con law almost accidentally, right? You're asked to give a 10-minute talk on it, and then that basically changed your life?
Yeah, I mean, actually, the connection there is a connection you and I have, which was a student who I had taught at Institute for Humane Studies summer seminar, as you had attended, went from Harvard Business School. He got his MBA to Stanford Law School, and then he was the conference director of the 5th annual Student Symposium of the Federalist Society, which was on the First Amendment. And so, knowing me, he invited me to be on one of the panels. And what I told him was, Brian, and his name is Brian Brille, Brille. He was the guy. Now he's a senior lawyer, maybe retired by now for all I know. But I said, Brian, I don't do the Constitution. I actually, have an aversion to doing the Constitution. He said, yeah, I know, but, you're a smart guy and, you only have to talk for 10 or 15 minutes and you can think of something to say. And I really wanted to go because there were a lot of fancy people on the program that I wanted to hang out with. I wanted to be a part of. I was a very junior, obscure law professor at Chicago Kent College of Law at that time. So I said, sure, I'll do it. And that was the beginning of my demise. That was the beginning of the end for me.
Well, I think you mentioned that when you started hanging out with folks at the Federalist Society, sort of conservative people, you said they really didn't have any theory. It was theory was absent, was missing in this conservative legal movement.
There was no theory. We talk about originalism now. Let me just tell your audience, who I assume are not going to be familiar with it. They've heard the name perhaps, but not the label. But originalism is the view that the meaning of the Constitution should remain the same until it's properly changed by amendment. Which, you put it that way, you can't imagine why it would even be controversial. But I'll say it again. The meaning of the Constitution should remain the same until it's properly changed by amendment. That's the position. Of course, being able to summarize it in one sentence requires you have a theory of what you're talking about. And the term originalism itself was coined by a critic of some people who were arguing with what today we would call an early version of originalism or proto-originalism. And that is a man named Paul Brest, who became the dean of the Stanford Law School. And he wrote a very well-known article in 1980 called The Misconceived Quest for Original Understanding. And it was a critique of two people in particular, or three people in particular. Two people, Robert Bork and Raoul Berger. And Raoul Berger had just published a big book 2 years earlier called Government by Judiciary that was published by the Harvard University Press. And he was using a version of what we would today call originalism, but there was no word for that. Brest, the critic, is the one who coined the word originalism or originalist to describe Bork and Berger. And then, because there was no theory of originalism, there were just these guys arguing for conclusions and using arguments. Brest constructed a theory. He constructed several theories before he refuted each one of them. That term, originalism, stuck. What ultimately happened is conservatives, at this point it was largely conservatives, who were part of this, who favored Bork and Berger and those things, they started responding theoretically to Brest, and they adopted the label for themselves. And so you can date the beginning of originalism from 1980, when Brest criticized Bork and Berger, and then into the 80s and 90s, there was a big debate about originalism. And I was persuaded by people like Ronald Dworkin. I was persuaded by Brest. And I was persuaded by Jeff Powell at UVA, who wrote the original understanding of original intent, which was another critique. I was persuaded by both of those critiques that originalism was wrong. And I wasn't committed to originalism. I was a contracts professor. It didn't matter that much to me. I would have considered myself a Dworkinian. Ronald Dworkin was my professor. He adopted what is sometimes called the moral readings approach to the Constitution. You want to make the Constitution the morally best it can be, given what it says. That would have been my approach. Until this happened in 1986, I guess it was, or 1985. And I started doing work on two different provisions. First, the Ninth Amendment, which says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And then the Second Amendment, which has to do with a well-regulated militia being essential to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I did work on both of these areas, and I was doing work on the original meaning of both these provisions, yet I was not an originalist myself, which created what psychologists would call cognitive dissonance. I'm doing one thing while professing to believe another thing. And that's a mental state that is an unstable mental state in people's minds. And when that happens, when they experience cognitive dissonance, there's kind of a desire to reconcile what you say with what you do. And I won't, go into it right now, but I had an epiphany. By this time, I'm now teaching a seminar on constitutional law at Boston University, and one of the readings that I read gave me an epiphany for a theory of originalism that I had not heard of before, and that's how I began my transition to become an originalist, which I announced when I gave the Brendan Brown lecture at Loyola of Los Angeles in 1999 in an article, a lecture that was published called An Originalism for Non-Originalists, which is what I was. And that's when I put forward this new approach to originalism based on this epiphany I had.
Well, look, I mean, a lot of people in the legal community make a big distinction between process and outcome, right? And I think outsiders can be very cynical, and they say, well, a lot of people, particularly justices on the Supreme Court, will, pick the process that's convenient for the outcome that they're looking for. And I think, pragmatists would support this, and folks on the Warren Court might support this. And so it seems like judicial activism is just, it's like a epithet that you hurl at the people who are cranking out opinions you don't like. I mean, is there something to the cynicism that people might have about the politicization of the court? I mean, when we see that the opinions seem to fall on partisan lines, I mean, is there reason to be cynical of what justices and judges are saying that they're doing, or what legal academics are saying that they're doing?
Yes and no. Both yes and no. Now, I already sort of laid out the difference between private law theory and private law and public law, which is constitutional law. And that's why I said private law is a inherited body of complicated doctrine that's been developed over centuries, in England and the United States. And there, courts really do tend to try to figure out what the law is and try to apply it as best they can. And so the law really does drive what they do and drives what the lawyers are willing to do as well. Even if you've got a good case on the law, then you're confident. If you don't, you don't. Con law, I already said, was kind of a form of high-level bullshit in the sense that these doctrines that do exist are kind of superimposed over something else. So what is the something else? So the most cynical view, which is associated with legal realism, is that, and this is something taught to law students, and it's been taught to law students for decades. And it can be a self-fulfilling prophecy. If you tell people this often enough and they get into a position of authority, they can literally do what you told them to do, which is to decide what the outcome is you like. And then having decided what the outcome is you like, and you like it for, let's say, for political reasons, for moral reasons, I'm not saying you just like it, but you have your own reasons why you think this is the right outcome. Then you marshal whatever evidence you can on behalf of that outcome. And it's actually how constitutional law tends to be taught. Not by me, but I think the most common way of teaching it is to divide the students up about how many people like abortion, how many people don't like abortion, and then get the students who like abortion to come up with as many arguments as they can on behalf of a right to an abortion, and have the people who don't like it come up with as many arguments as they can against it. But notice they're starting with their prior, and then they're after the fact utilizing arguments to support whatever conclusion they began with. So that's kind of the legal realist view. There's a lot of truth to it, except I would qualify it. And that's the yes part. Now here's the no part. I think what really motivates, and the medical marijuana case is going to be a good example of this. What really motivates these justices, apart from the doctrine, which I think doesn't really motivate them, that means the law is not motivating. What really motivates them is what I call constitutional principle. They carry within their minds some fundamental constitutional principles. And those principles kind of dictate what they think the right answer is. And at that point, they will start marshaling doctrine on behalf of that. But it isn't merely the policy outcome of the case. That's the difference. For the legal realist, the pure legal realist, it's just what outcome do I like? But I think most justices, it's what constitutional principles do I hold dear that I want to see vindicated or do I believe will be undermined if the other side should prevail. That's a big difference. It's not the same as contract law, where you're trying to follow the actual law. Here you're trying to follow your principles. And then the reason why the court seems politicized is because there has now been a polarization of the two political parties. So we didn't used to have this, and I'm not sure it's really. I think it's actually a good thing we do, but we didn't used to have this. Both parties were more or less similar to each other. There wasn't all that much difference between a Republican and a Democrat. At the margin, there might be some policy differences, but they shared the same rule. But beginning in 1980, again, coincidentally 1980, and this is with the election of Ronald Reagan, the Republican Party started to become a more conservative party. It was a more politically conservative party. That movement began with Barry Goldwater, who the memoir tells you I debated on behalf of Barry Goldwater in front of my entire grade school and junior high school student body when I was 12 years old in 1964. And in my heart, I believed he was right. I still do. But it was Goldwater who was basically an insurgent, representing an insurgency within the Republican Party on behalf of political conservatism. You think William F. Buckley Jr. and people like that. With Ronald Reagan, now he lost. He got his head handed to him. But that was 1964. By 1980, 16 years later, now Richard Nixon, in the meantime, gets elected. But then Ronald Reagan really represents somewhat the triumph of the conservative political movement within the Republican Party. Now you're setting up a tension between the two parties that didn't previously exist. And then what's happened since then is the Democratic Party has moved increasingly way to the left. They used to be dominated by a mix of liberals and leftists. And the liberals really, the Hubert Humphreys of the world, the Fritz Mondales of the world, the Daniel Patrick Moynahans of the world tended to be who was the mainstream of the Democratic Party. But for many reasons that we don't need to get into, the party has moved way to the left, and the liberals no longer dominate the party if they're even allowed to be in the party. Donald Trump was a Democrat. Ronald Reagan was a Democrat originally. As a result, we have real polarization now between a conservative Republican Party, more or less conservative, and a more or less radical left Democratic Party that's become more and more radical in very recently. Now, why does that matter? It matters because of how the Supreme Court is chosen and the lower courts are chosen. The Constitution anticipates that the justices and judges, but let's just focus on the justices now, are going to be selected by a politically elected president and confirmed by a politically elected Senate. And so who gets picked can actually will be dependent on the political party of the president, the political party of the Senate. And that's going to make a difference if it turns out that this polarization has led to a conflict in judicial philosophy and vision of the Constitution between the two parties. If the two parties now hold a different view of both the Constitution and the proper role of judges within the Constitution, if they hold different views of that, then their nominations are going to reflect the differences in those views. And that's going to politicize the nomination and confirmation process, which is what we've seen. And it's going to seemingly politicize the decisions of the courts. But let me go back and reemphasize, the disagreement here is one of constitutional principle, not naked partisanship, not naked policy preferences. It's not to say that any of our principles aren't related to policy preferences. Of course they are. But the question is, do we mediate our political preferences, our policy preferences with our fundamental principles? I think the justices tend to do that. Republicans will pick justices who have a certain judicial philosophy. And Democrats will pick justices with a different judicial philosophy. And when they both get on a collegial court of 9 members, they're going to start having fundamental disagreements about how cases should be resolved consistently with their constitutional principles. Does that make sense?
Yeah, but while the political world has become more polarized, it seems like the legal community or the judges and justices, there appears to be a bit of convergence. You talked about how Justice Kagan and Jackson, they both sort of said, we're all originalists now, right? So it seems like the legal realist position has been discredited to some degree.
Well, not if you think that they still act on the basis of principles and not on the basis of doctrine. What the realists were reacting to was the claim that judges' decisions are based on what they think the law is. So they go off and they find out the law, and having found out the law, that's how they rule. And they say that's a fiction, that's a myth. And I think with respect to contract law, it is largely not a myth. It's largely reality. But with respect to constitutional law, it is not really a myth. It's more accurate, except all I'm saying is that it is not the policy preferences of the justices that they act upon. It's their political principles, which now vary. Now, let me use the medical marijuana case as an example. So I brought that lawsuit with 2 other lawyers on behalf of Angel Raich and Diane Monson in the Northern District of California in order to argue that the Controlled Substances Act, the Federal Controlled Substances Act, was unconstitutional as it was applied to users of medical marijuana in California as authorized by state law. And so the states had the principal role in being able to authorize conduct. They authorized it. Now the federal government is telling individual users they can't do something state law says they can do. And we argued on behalf of the state of California, really on behalf of our clients, but who were asserting the Compassionate Use Act, which would have been passed by the voters of the state of California. And so you would think, let's take, marijuana is kind of a lefty thing. It is a liberal thing. It is not a conservative thing. Conservatives are down on drugs, and lefties are big on, were big on marijuana when I was in college. And I should say I've never smoked marijuana myself, even though I was a student in the 60s and the 70s. And I became a marijuana lawyer. But nevertheless, it's a lefty issue. That's why it came out of California. But how did the votes turn out in Raich? Well, it turns out we never had a shot at all to the left side of the court. We never had a shot at all with Justice Stevens on the left side of the court. The 3 votes we got were Chief Justice Rehnquist, a conservative, Justice Thomas, a conservative, and Justice O'Connor, who was big on federalism, a Republican, and a conservative, maybe a more moderate one. So how do you explain? And based on, and even in her dissenting opinion, Justice O'Connor said, if I were a legislator, I would never have passed this law. And interestingly enough, Justice Thomas joined every part of her dissent except that paragraph. So he did not want to commit himself on the policy grounds. But how do you explain that? I mean, that's a challenge for anybody listening to this who thinks that I'm being naive or overly idealistic. How do you explain the fact that all the liberals who ought to have compassion for cancer patients and other people who need medical marijuana, we had no shot at getting them, and the people we got were conservatives who obviously would probably supported the war on drugs? And I think the answer is their principles, that the progressive justices put their commitment to almost unlimited federal power, a principle of unlimited federal power above their compassion for the sick and the dying. And at some level, you have to admire them for putting their principles first over their compassion. And I think the same thing is true of the three justices that voted for us. They put their principal commitment to federalism and the fact that California ought to be able to make this decision for its people over their antipathy towards marijuana and drug use. That, I think, Rach, is a fair exemplar of what always is happening at the Supreme Court level.
Mm-hmm. Well, of course, a lot of people will accuse the Supreme Court of judicial activism, right? This seems to be the accusation that you launch whenever you don't like what the Supreme Court is saying. And it seems like that accusation has flip-flopped, right? So, in our history, half the time it's conservatives who are accusing the court of judicial activism, and half the time it's liberals that are accusing the court of judicial activism. I mean, is there a way that we can objectively, right, measure whether someone is engaging in judicial activism?
I think the term activism is a completely empty concept. It is more like what you said earlier. It is a label to be peeled off and stuck on a decision that you don't like. And it's a sort of a process objection, which allows you to avoid having to talk about the merits of the constitutional argument. You say, oh, this judge is overstepping their authority. They're engaged in activism without having to say, well, what's wrong with what they said about the Constitution or whatever. And so because it's empty, anybody can hurl it. Now, there have been people who've tried to give sort of content to this concept. And one of the hallmarks of what's considered activist is if and you'll recognize this rhetoric, if an unelected, lifetime appointed judge, unaccountable judge, overrides the will of a Democratic majority as expressed by a democratically accountable legislature, that's activism. In other words, it's judges getting in the way of the legislature is activism. And that is kind of how the term originated. It originated by Arthur Schlesinger Jr. coining this term when he was essentially implicitly criticizing the new legal realist Yale law justices on the New Deal court, the post-New Deal court, and more siding with the Harvard justices who were more interested in judicial restraint, Felix Frankfurt. The Yale judges were exemplified by William O. Douglas. The Harvard justices were exemplified by Felix Frankfurter. They were all New Dealers, and so was Arthur Schlesinger Jr. But he basically wrote this piece in 1948, or it was 46 or 48, characterizing the Yale people as activists and the Harvard people as lions of judicial self-restraint, he said. And that's where the distinction first came from. But if it means just the court invalidating a democratically enacted law, everybody's an activist, because almost nobody, I can think of a couple exceptions, but almost nobody says the court should always just follow what the legislature said. Almost everybody thinks the court should invalidate an unconstitutional law. So the real debate isn't whether you've invalidated a law or not. The real debate is whether you have a good legal argument for doing so. So activism really doesn't advance the ball at all. But what it does is it allows politicians to get up in front of a microphone when their law has been struck down that they wanted to see upheld and say, those judges are engaged in activism, and they don't have to say, well, what was wrong with what the judges said was wrong with the law. So I always urge people to abandon the term activism, but if I had to use it if I had to reserve it, you made me put a gun to my head and made me use the term, I would say an activist judge is one that is either upholding a law or invalidating a law without an adequate grounding in the Constitution. regardless of which way they come out, a judge that deviates from the meaning of the Constitution, I would say the original meaning of the Constitution, is being activist. But I don't use that term. I maybe once in a while I've slipped up and I use it, but generally speaking, I try to avoid it.
Now, I think a lot of people think that Supreme Court justices are trying to please a political audience, right? They're trying to please their friends in the legislature and so forth. But it seems to me that, if anything, they're trying to earn respect within legal academia, right? So to what extent does legal academia influence or shape the thinking of judges and justices?
I think you're right about that. I mean, I think they want the respect of their peers. I think, by the way, that's one of the problems with Chief Justice Roberts, and that is, I think Chief Justice Roberts would be a different justice if he was an associate justice. Then he's the Chief Justice, and there's something called the Roberts Court, and he wants the Roberts Court to have the right people to think fondly of the Roberts Court amongst the intellectual elite, which are generally in the law schools. And so, yes, I think that does motivate them. Their peer opinion motivates them more than their public opinion does. Not that they're completely immune to public opinion. Nobody is. But I think that motivates them. But the reason why the rise of the Federalist Society has been so significant is not because it's a grand dark money conspiracy. We could talk about what it is and what it isn't. But one of the things that it has created is an alternate group of peers. And so, in some sense, people who come through the society and who share some of the common values, although there's a huge amount of diversity and disagreement within this people who are in this group. Nevertheless, there's some common values. They want to be thought well of by their peers, and their peers are not the Harvard Law School faculty or the Georgetown Law Center faculty, but they are people who are the movers and shakers in the Federalist Society. It's not the people who run the society. That's a small group of administrators. It's their people who are members. Their fellow members are their peers. It's their group. And that is who I think they don't want to disappoint. So what happened was the Federalist Society set up a rival peer group that's responsible for who justices want to appear to be doing a good job. They want to have people think they've done a good job in doing their job.
Now, look, a lot of people talk about the ideological skew within academia. And I think maybe if we're looking at fields like, I don't know, sociology and anthropology, this is something which is understandable. But when we look at legal academia, it doesn't seem to be matched by the distribution of opinions within the broader legal community. And certainly, the con law faculty is different from, say, the private law faculty. What accounts for this? Why would we ever expect to see a non-representative group of opinions in a discipline like con law?
Well, it's a long story, and it's probably got many, many factors, and it would be difficult to boil it down to one. This is largely driven by the fact that faculty appointments are faculty driven. We have faculty governance, and so the faculty have to agree to appoint somebody. They usually initiate the appointment themselves through a appointments committee, and then they have to pass upon it. And what's happened over the years is that the law schools, which were dominated by what I would call liberals, and then there were some conservatives and there were some to the left of them, have been increasingly dominated by those on the left, in part because the liberals have taken on kind of a no enemies to our left approach, in which they view leftists as people who share their commitments and yet are just more radical, or they want to get there in a bigger hurry or whatever, but they view them as friends, whereas liberals view conservatives as kind of the other. And so as a result, liberals hired an awful lot of people on the left, and those leftists are not liberals and they are not tolerant. And as a result, some liberals have gotten themselves in trouble in law schools, but the law schools themselves have started to be have become dominated by the left, even though they don't control 100% of any law school. Nevertheless, because of faculty governance, all you need is some opposition to a candidate, and that candidate's never going to get off the ground. I mean, at Georgetown, I know there's an individual professor who, if he's on the committee, a political conservative is just not going to survive the committee. He's very stealthy about it. But it just so happens he will raise objections to virtually anybody who's right of center who comes through the committee when he's on the committee. And he's respected on the faculty as a scholar. And so there's a certain amount of deference. In that case, it can take just one. I think Yale Law School lacked any originalist on their faculty because they were being blocked by one member of the Yale Law School faculty until recently. Now, it's even worse if there's a group of people who block people. But as a result of this, hiring has been completely skewed. Now, there have been some secondary effects that are going to make it difficult to rectify. And that is because students who come through legal academia are aware of all this because they see it all around them. You can't, no matter what you say, they see it firsthand. If they might have aspired to be a legal academic, that takes investment. You have to invest time and energy in gearing up to be an academic. I did that, and not as much as you even need to do it today. And what are they going to do? I mean, if they think the bottom line is always going to be they're never going to get a job, they're not even going to do the upfront investment in getting the credentials and gearing up to the point where they could do the job. And so they go off into law practice and they do whatever they're doing. And they don't even think about being a law professor because of that. Now, what's happening now is there's actually somewhat of a demand for more diversity on law school faculties today. And there are new centers being created in undergraduate, many universities which are hiring people who are right of center to teach undergraduates as well. And we have a real pipeline problem because we don't have a lot of students coming through PhD programs now to staff some of these undergraduate programs, and we don't have enough law students of our best law students coming through the academic pipeline to staff whatever jobs are available now in law. And even a good faith search for a right of center law professor by a left-wing faculty committee or a liberal faculty committee might come up empty, in part because of this chicken and egg problem that's been created by this really overpowering discrimination against people on the right for so long. And my story, my memoir, is also a story of the discrimination that I personally experienced, both in getting an initial job and in getting subsequent lateral movements to other law schools.
Yeah, so I think in the book, one gets a sense of the academic career journey in the legal academia. And, it seems like initial conditions matter a lot. So, I mean, you quote Richard Epstein, who said that you can write your way into any position.
Exactly. You can write your way out of any law school, he said.
Yeah, but I mean, it's not as easy as that, right? I mean, your initial appointment makes a big difference, and your initial experience makes a big difference. And so, being a prosecutor in Chicago isn't exactly the same as, say, clerking for the Supreme Court, right? And do you think that that kind of path, the system that we have for internal promotion and advancement within legal academia, I mean, is that something that could use a tweaking or some kind of reform?
I think not necessarily. I think jobs candidates come through now more intellectually prepared to be scholars than they used to be. The problem is that it's only one side of this intellectual equation that gets represented really almost at all, except at the margin. And the other problem is that even if you did have a pipeline, which I think we don't have a good pipeline, but even if you did, faculty appointments are only taking place at the margin. Georgetown has over 100 faculty members, more like 120. In any given year, we might be hiring 1, 2, 3 people, maybe 5 people, but usually for specific subject matter needs. And how are you going to balance this? We now have 4 identifiably right of center people at Georgetown out of 125. How are you going to balance that faculty off? You'd have to make every appointment right of center for the next 20 years just to create a minority faction within the Georgetown faculty that means anything. And that's never going to happen. And so that we have the left likes to talk about structural racism. We have a structural problem. This is a structural problem that's independent of individuals' motives and intentions. You could be of the best intent, although many professors are not of the best intent, but you could be of the best intent and still not be able to do much about this. A dean could be of the best intent and still not be able to do much about it. Georgetown hired a right of center law professor last year, Stephanie Barkley, who's now my colleague. And it took a lot of effort. Now, the dean had to, had to put in effort. I had to put in effort. Chairs of the committees had to be fair, which they were. A well-balanced committee had to be selected, which it was. And even so, we had issues we had to overcome with some of the people, like this individual I'm talking about, who would try to throw up roadblocks along the way, and we succeeded. But that was a lot of work. So then we went from 3 to 4. So great. I'm so happy. And so are the students. But that's not going to, we have a structural problem. We can't do much better than that.
Well, do you think that when it comes to constitutional interpretation, that there's maybe a missing piece in the educational system? I mean, I remember that some of the courses that were most valuable to me, that really helped me to understand con law, were courses on legislation, right, and legislative interpretation. And that sort of helped me to connect my understanding of contracts with my understanding of con law, right? And so, one of the folks who taught the course was a judge on the federal circuit, and another one was someone who had worked in the White House. And that really kind of light bulbs went off, right, when we had to sit down and just try to figure out what a piece of legislation meant. And it was informed by debates over intent versus meaning and so forth. I mean, do you think that maybe courses in legislation might help people to approach constitutions differently?
I mean, personnel is policy. And look, if you want to be a realist about judges, why can't we be realists about law professors? Why does realism and judges exercising their political priors, why does that only apply to judges? How are law professors immune from the same sort of legal realism that judges are succumb to? And I think they are not. But I would also say that law professors are also guided by what they think of as their constitutional principles, just as like I say that about judges, except there are now fundamental disagreements about those principles. Both sides are motivated by principles, but they don't share the same principles now. And so there's a fight. There's a fight over that. And this fight is going to take place in the political realm because it's a political system in which the judges are picked by a political president and confirmed by a political senate. And back in the law schools, in con law, they're playing the same kind of game. And law schools are 99.9% Democrat. And of that, I would say they are more the radical Democrats as opposed to the more moderate Democrats. And they're completely out of touch with half the country. I mean, there's just no question about it, and which means they're out of touch with maybe 30% of their students, because law students typically are more left of center than right of center for whatever reason. But there's 30 to 40%, depending on where you are, and in some places it might be half, who have a view that their law professors not only don't understand, but think is morally reprehensible. That to hold the views that I hold, they think you must either be stupid. Of course, in my case, it's hard for them to say that. And if you're not stupid, then you really must be immoral. You must be fundamentally immoral. And I even get that on Twitter or X. That is, people say they used to have respect for me, but then when they hear what I think, then they lost all their respect for me, because obviously nobody can hold the views they disagree with without, and they can't respect anybody who holds views with which they disagree. And I think that is the way a lot of people feel. And truthfully, I think if conservatives and libertarians, but mostly conservatives, were in the majority, they'd probably have a similar pathology. They'd probably, think ill of anybody who was to the left. I think the problem here is, to the extent it's structural, is it's majoritarian problem as opposed to simply an ideological problem. I think conservatives today are more interested in freedom of speech and diversity of viewpoints as opposed to other kinds of diversity, partly because they're in the minority. And it used to be the left was really concerned with political speech when they thought they were in the minority. And so some of this is just this is majority faction. This is something Madison taught, observed in Federalist 10. And even in his essay he wrote before the Constitutional Convention called The Vices of the American Legal System, in which he said, the problem is factionalism, and in particular majority factions who tend to abuse the minority. And that's what we're witnessing in law schools today.
Now, look, you've been calling yourself a libertarian since college, I guess.
Yeah.
And I think if we go back to those days, folks who called themselves libertarians were definitely on the fringe, right? Were considered eccentric.
And the term itself was considered weird.
Yeah. And so I think your life has coincided with the mainstreaming of libertarianism. And part of it is due to rebranding. And you discussed the rebranding that took place, right? Classical liberalism. But now it seems like libertarians have found a home in bed with conservatives, right?
I'm going to have to dissent a little bit about this. Maybe not in the way that. Here's what a normal libertarian intellectual will say in response to that: and said, "Well, we're not conservative and we're not liberal. We transcend that distinction, and so we're above those things. Don't call me a conservative." This is something that just kind of been a libertarian reaction for as long as I've been a libertarian. But I actually think there's a divide amongst libertarians now. And there are some libertarians who are operationally really on the left. And they also talk about markets maybe, or free markets, but that's not really what's motivating them. They really more have a left sensibility, and they happen to subscribe to most of the left policy programs. And here's the most important thing, going back to peers, they want the social approval of the left. And they'd want to be disassociated with the right. There's a lot of libertarians in that category. I am not one of those. There are other libertarians, and many of them are lawyers. I think they happen to be more lawyers than anything else, who actually are more part of the conservative legal movement. And so they really are. I consider myself a part of the conservative legal movement, though I'm a libertarian, and I would distinguish that from being a conservative. Nevertheless, I do accept the fact that my views are on the right, whereas other libertarians would bristle at the conception, any accusation that they might be on the right. So I do think that within libertarianism, there's a schism itself. And this is an unrecognized schism. This is unrecognized both within libertarianism, to the extent there's such a thing, and it's unrecognized by people who are outside libertarians, looking at libertarians, who tend to stereotype libertarians as one of these groups or the other. Primarily, the right will stereotype libertarians as being on the left in a way, and the left will stereotype libertarians as being on the right. And so there's a lot of stereotyping going on. My next book is going to be about a reconsideration of libertarianism, but first principles libertarianism, because one of the things that libertarianism has lacked is an institutional structure in which its theory can be developed, refined, contested, and improved upon. That's something originalism has enjoyed within the conservative legal movement for 30 years because of the Federalist Society. We have debated each other incessantly for 30 years on what the true form of originalism should be, or maybe whether we shouldn't be originalists at all. Libertarians stopped debating each other about first principles in the 1970s with the end of, or the early 80s, with the end of the Center for Libertarian Studies, which I was on the board of directors of when I was in law school. That was an intellectual group. The Center for Libertarian Studies, we had an annual Libertarian Scholars Conference. We had a journal called the Journal of Libertarian Studies. And what we were debating amongst ourselves were libertarian first principles, not policies, not immigration or drugs, but for libertarian first principles. What were the rights of children? What are the rights of parents? Things like that. That stopped. That ended. There is no institutional location for that kind of discourse to happen. There's no journal, there's no conferences, there's nothing. And so now, that's been 30 years. Libertarianism per se has been frozen in amber since the 1970s and 80s. It hasn't changed at all, the theory, but no theory should be frozen in amber. Theories need to be contested, and they need to be improved and refined and improved upon. And we lack that. And as a result, libertarianism has tended to be reduced to a series of policy positions that you either hold or don't hold. So if you're not open borders, you can't be a libertarian somehow. If you believe that some use of military force outside the borders of the United States might sometimes be justified, well, they can't be a libertarian because libertarianism has been reduced to a list of policy positions as opposed to first principles. Even though libertarians love to say it's all a matter of first principles for them, they would be hard-pressed to actually explain what those first principles are, in my view.
Yeah, and I think you said that in early in your career, you were critical of libertarians for lacking any kind of legal theory. And I think your goal was to create a legal theory for libertarians. But now I think towards the end of your memoir, you say that what's also missing is sort of a view of the good life, right? A view of, and I think for someone who was schooled in Thomism and Aristotle as an undergraduate, right? I think it's almost like you're going back to your roots, right?
For sure. Well, I was a natural law person before I was a natural rights person, before I was a libertarian. Only by a matter of like 2 years. I mean, it wasn't a big gap. But I never left natural law behind. An Aristotelian Thomist version of natural law. I was under the my mentor was Henry Veitch, who was a really well-known Aristotelian philosopher back then at Northwestern. And so I never lost that view, but I did theoretically accept, and I have an article that says this, I accepted the view that libertarianism was a political theory, not a moral theory. And it was compatible with competing moral theories. And therefore, it sort of stood by itself as a political theory. I have, that is the conventional view. I think it's a reasonable view. It's the view I held and have published. I now think that's inadequate. And even Murray Rothbard, I believe, in the last few years of his life, acknowledged that this was inadequate. That, in fact, you need a moral foundation for being a believer in liberty. Liberty is not an end in itself, although some libertarians think it is. It's a means to an end, and the means to the end of human flourishing. And so that will shape what you think liberty is. And how liberty can best be protected if you believe that's the case. And I think I do believe that's the case. I never didn't believe it, but now it's become much more relevant.
Mm-hmm. Do you think that the general public needs to learn more about the constitutional arguments? And I think journalists play a role. I mean, when I read journalistic coverage of Supreme Court opinions, I mean, they seem to all be deeply legal realists, right? I mean, do you think that the legal journalist community needs to maybe think a little more seriously about some of the procedural debates and arguments? Do they need to be educated about this so that they can communicate it to the general public?
Yeah, but it's hard to expect them to be any better than law professors are. My experience with reporters is that they're basically very bright. It's like having a really bright student, and they're tasked with writing a story about something that they don't know much about, that's true of all reporters on every subject. They learn the subject from their sources, and it's kind of up to their sources to educate them. And when I was doing the medical marijuana litigation, that was one of my jobs, was to talk to the press privately and explain to them the theory. I was actually hired to do that by the National Federation of Independent Business for the Obamacare challenge, because the lawyers from Jones Day who were doing our brief writing, they didn't want to talk to reporters all day long or go and sit in green rooms waiting to go on CNN, MSNBC, or Fox News. That was my job to do that. And I found that that reporters were really eager to hear what the other side was if you approach them not as adversaries, but as students. Now, I have to say, for those people who think I'm being naive, if the reporters are going after you, you can't expect them to be fair about it. But they distinguish between targets and sources. I was always a source. I was not a target. If you're a target, you want to stay away from them. If you're a source, they value you. They don't want to burn you. They want to cultivate you. They need sources. And if you approach them as in good faith and try to explain your view, they try to understand it. And so I approach reporters as a professor would approach a student. because that's what they are. They are bright students of whatever subject they have to report on, and they want to write a balanced report by and large. But you have to have that skill set in dealing with the reporters, and not that many people do. And I don't talk to reporters all that much because I won't. The other thing, here's a problem with them, and it's not their fault. They have a deadline. Some big thing happens, maybe it's whether the president is qualified disqualified under Section 2 of the 14th Amendment. What is the limits of birthright citizenship? I mean, just name it. All of a sudden, something bursts forth. They have to write a story about it. They have to go out and find a source. I just had this experience with the Free Press, which is an outlet, Barry Weiss's outlet. I really I like a lot. I'm a paid subscriber to the Free Press, and they wanted me to opine on some stuff that was happening in the last 2 months, or in the first 2 months of the Trump administration. And I said, I just don't know enough about the statutes that are being asserted exactly. I haven't read the EOs, the executive orders, to see what authority they're asserting. I just don't know enough about it to be an expert and write for you on these opinions. And the response I got was, well, you know more about it than other people do. Well, that may be true, but that doesn't make me an expert. And so they were disappointed that I wouldn't write for them on these topics because I didn't feel I was in a position to be able to do so authoritatively. And as a result, I'm turning down press inquiries a lot more than I'm responding to them, and to the detriment of the press. But I still don't feel like I have a knowledgeable opinion on all of these issues. Just because I have a JD, and even just because I am a law professor that teaches constitutional law, doesn't make me an expert on every facet of constitutional law.
Well, Brandy, thanks so much for joining me. This book is called A Life of Liberty. It's a really wonderful memoir. It covers a lot of ground and a lot of topics, and I think it gives you a little bit of an introduction to the much richer work in these other books.
And can I say that this is a book that was deliberately written for younger people to read? I mean, it's great if you're an older person. I think there's a lot of stories in there you'll appreciate as well. But this is really written for somebody who is kind of out of it, like I was. And I'll give you an example of how out of it I was. I grew up in a place called Calumet City, Illinois, which was a town of 28,000 south of Chicago on the border of Indiana, culturally more a part of Northwest Indiana. My aspiration was to attend the University of Illinois because that was like the best school in the state. That's all I really thought about. And I got my SAT scores, and my guidance counselor had me meet him in his office, and he said, with your SAT scores, you can get into Northwestern. And I said, really, where's that? Now, for those of you who don't know, Northwestern is in Evanston on the north side of Chicago, and here I'm on the south side. That's how isolated I was. My parents were less isolated than I was, but it didn't pass down to me. And so I came from that kind of completely out of it. I mean, I'm the first person in my family to go to college, obviously the first person to get a law degree. I went all the way from that to being a chaired law professor at Georgetown Law School, to the point where a publisher like Encounter will publish a book about my life. How did that happen? What did I do to make that happen? What can you do to make an impact? What can you do to make a difference in your life? And I try to draw lessons from my own life, including being very candid, I think you'll admit, about my mistakes and also my character flaws, of which I have some, believe it or not. I think people who are younger people can read this book, A, be inspired by it, but also B, take it as reassure them that they can do it too. I'm not perfect, and I'm not the smartest kid in the class, although people thought I was, but I wasn't. And you can do it too. And I think this is a book not only for a young person to buy, but for a senior person to buy for the younger person in their life who might want to go to law school, who might want to have an impactful career. Buy this book for the person in your life that you want to see live a good life. And I think that might be helpful.
Well, also it gives you a window into what it's like to be, I mean, this is what memoirs are for. It gives you a window into what it's like to be a law professor, right? What that life looks like. I mean, there's less on the drudgery of, footnotes and all that. But I wish when I was young, I had any clue as to what the life of a law professor was. I mean, I didn't even know that one could be a legal academic. Right?
I didn't either.
I
didn't know what that was.
There's no undergraduate law major, and so when I was an undergrad, it was just like, oh, okay, I can do PhD in econ, I can do a PhD in history, or I can do a PhD in political science. It didn't occur to me, because there was no PhD in law, that you could actually go to law school and be a legal academic. I had to kind of figure that out later. So in that sense, it's really a great window into
it's also a great life. I wasn't actually even able to go into all the extent to which it is a great life. You're interviewing me now. I'm here in Sarasota, where I spend half the year. If you're really good at this job, it's a really good life. I mean, the people that for whom it's not such a good life are the people who aren't as good at it, of which there are many. But if you're really good at it, man, there's so many perks to the job, and I just couldn't be happier with how everything turned out for me. And I think the book was written in part to inspire others to achieve something similar.
Mm-hmm. Well, Randy, thanks a lot for joining me. Again, book is called Life for Liberty: The Making of an American Originalist.
Thanks,
we'll
Greg.
Talk again soon.
Unsiloed podcast is produced by University FM, elevating the stories of your institution.